Thank you, Your Honor. Your Honor has obviously reviewed our brief. I'm happy to answer any questions that you have about it, but I will be brief in my comments. I don't have a whole lot to say beyond what we have argued and laid out in our brief. Um, I do have a couple of points I want to address that Mr. James raised, but at the end of the day, the city's the man in the middle here. If there were an option set forth in the statute that allowed these records to be fired into orbit, into the sun, I think, in my heart of hearts, and I'm pretty sure Miss Batista's as well, we would just as soon not release these records. Nobody gets them. These are harrowing images. This was a horrific crime. I don't think that anybody could reasonably say otherwise. And I equally think that it would be difficult, if not impossible, to dispute that family members of victims of a crime as horrific as this, of course, they are distressed, will be distressed, would be distressed by the release of any materials relating to the crime. I can't dispute that. I don't want to dispute that. And the city has not to this point and does not intend to dispute that. The declarations that Mr. James has filed on behalf of his clients lay out in sufficient detail that his clients, will find the release of these materials distressing. That's not in dispute. The problem is the way the statute is written, at least as I understand it, and as I know Ms. Batista understands it, there's equally little dispute that the materials we're talking about here qualify as investigatory records under the Idaho Public Records Act. And there are several exceptions. There are several exceptions written to the statute. Existing case law says they are to be construed narrowly. And to the best of my knowledge, the only exception that has any plausible application to the materials we're talking about here is the unwarranted invasion of personal privacy exception set forth in, I don't have the code section in front of me, but I can pull it up in just a second. Should have had it in front of me. My apologies. Set forth both in Idaho Code Section 74-124, and the definition of personal privacy is further defined in Section 74-101 sub 17. And to follow up on the court's second question to Mr. James, that is, I don't know, it might be the crux of the matter if Your Honor reads this provision and gives it its plain and ordinary meaning. It defines the right of, what is, who can raise this privacy interest in a fairly narrow and restrictive sense. I don't dispute that it was written against the backdrop of the common law, and I also don't dispute that if we go look beyond Idaho, the United States Supreme Court has discussed, what I understand at least. It's not entirely clear from Justice Kennedy's opinion, but I understand him to be talking about the common law right of privacy there, that the federal FOIA statute was written against as a backdrop. But the statute itself in Idaho is quite narrow in terms of the privacy interest that comes into play when you're talking about the right of privacy or unwarranted invasions of privacy for these purposes, for purposes of reading this narrowly construed exception to public disclosure of investigatory records, which again is required by statute in Idaho, for good or for ill. And I'm not going to go through what I wrote in my brief. Your Honor has it in front of Your Honor has it. If you have any questions, I'm happy to answer. But the bottom line is the type of privacy interests that are talked about in Idaho Code 74-101 sub 17, they don't clearly apply here. The only interest that is talked about that might, I think, is, in terms of interests of deceased parties, it uses language that is not applicable here. And the other section that applies, or at least has plausible application, is the provision that talks specifically about unwarranted invasions as weighed. It imposes a balancing test. I don't know how you can read Idaho Code 74-101 sub 17 and not come to the conclusion that you can find a privacy interest. You can find whether it inures to the benefit of the deceased, the victims themselves, the family members, whether they are victims themselves as a matter of other statutory provisions or not. It's still a balancing test. Whoever, whether it's the city or a court that is brought into the mix, has to weigh the competing interests. And the competing interests are the interests in privacy, which, whether you find that the family members that have brought suit here have an interest in privacy or not, it still has to be weighed against the interest in public disclosure. And as I've also set forth in my brief, the city has received numerous requests for these materials. The city has received almost more than 1,150 total, and 250 of them specifically asked for images, body cam video, whatever. I may have the numbers slightly wrong there, but the bottom line is the city has received, at minimum, a couple hundred requests that cover investigatory records that include photographs, videos, whatever else the city's officers collected when they responded to this crime and investigated. Whether I personally, whether anyone personally thinks these images should be released or not, the city has a duty under the statute to release them on request, unless an exception applies. And as even Mr. James acknowledged, the city doesn't get to ask why. The city doesn't get to look into, quiz the requesting parties on why they want these images. And for lack of a better word, I struggle to understand why members of the public want these images, but I'm not the one who's made these requests. And equally, I unfortunately know that we live in a time when conspiracy theories, and as Mr. James referenced, the world of true crime, it's a big business, it's a big industry. Conspiracy theories run rampant, and as I cited in our brief, there are a small but vocal segment of individuals who, even after Mr. Kohberger pled guilty, admitted his guilt, admitted responsibility for these horrific acts, they still think that he might be innocent. I don't know what there is to say other than the reasons why any individuals would want these images. It's difficult for me to wrap my head around. But that is, unfortunately, under the way this statute is provided and written, that isn't the question. The question is whether the public has a right to look at the affairs of the public officials that run the government, investigate crimes, and prosecute crimes. There is no investigation ongoing. The city can no longer say, look, we can't release these. There's an investigation ongoing. It will impede the administration of justice. For good or for ill, the materials have to come out unless an exception applies. And the only exception that applies here is one that requires a balancing test. And as far as I can tell, the city applied that balancing test to these images and crafted what I think is the only sensible balance. The materials that the city has provided to the court, the initial redactions, and Mr. James characterizes blurring of images as not redactions. I don't know how exactly to respond to that. If they're not visible because they're blurred, or if they're not visible because there's a black block over them, if you can still see the rest of the room, that seems like a fairly trivial distinction. If the court intends to issue a order that requires that black boxes be imposed instead of blurred images, Ms. Batista can correct me if I'm wrong, but I think that the city would be probably amenable to that. I don't think that that is a hugely burdensome issue. Whether other parties that have requested the images would object, I don't know. The city could end up back in front of Your Honor or in front of some other judge in this district saying the flip side of this argument, which is to say, well, blurring is good enough. Why didn't we get the blurred images? Why do we have to look at black boxes or something similar? As I said, the city is in the middle here. The city is going to get it from either side, and there doesn't seem to be any way to avoid that. As far as Mr. James's suggestion that images depicting blood spatters or blood pools are body parts, I don't know. I don't have a particularly I don't know how to respond to that, simply put. If I'm cut and blood ends up on the floor, I don't think that is part of my body anymore. I know that there is a fairly extensive body of intellectual property law that gets into residual interests that individuals have in, for example, blood or DNA once it's removed from them. But to say that images of blood spatter is tantamount to and no different from a depiction of a dead body on the ground, I don't think that's a strange argument, and it's not one that I agree with. I don't know how exactly to respond to it other than to say I don't think it's accurate. I don't know how much else I have to say, Your Honor. At the end of the day, we are talking about an exception that requires public officials to conduct a delicate balancing test and weigh the public's interest in disclosure and the interests of family members or the deceased, depending on who exactly it is who holds the privacy interest, and release the materials that the statute requires to be released. I think the city did that here. If the city came up with a balance that is not completely where the court thinks it should be struck, we will accept your guidance. I mean, I don't think that there is necessarily anything in the statute that says one way or another whether a public official's application of this balancing test is due any discretion or due any deference. At some level, it's inherent in any type of judicial review of administrative or agency actions. But I mean, we're not here on a petition for judicial review. We are here under a request for injunctive relief or, I guess, declaratory relief of some sort. And the statute doesn't provide any clear guidance. I would simply say that the court should, just as a matter of principle, defer to the considered judgment of public officials in this area. But at the end of the day, weighting evidence is something that the court is very familiar with. That's what courts do on a daily basis. Whether that means that every particular decision made by the city in this case or any other case in terms of disclosure of investigatory records needs to come in front of a judge to be reviewed and ratified, I don't know. That doesn't seem like the scenario that the legislature envisioned, but perhaps it is. And I'd just like to conclude by saying that Mr. James suggested that this is, in some sense, a unique case. I don't think that's necessarily true. I think, unfortunately, a lot of the interest that he was referencing, the fact that the internet means that disclosure instantly makes whatever is released, it's around the world before the opposing party has their boots on. I mean, Your Honor is aware that my office was brought into this case very late. I wouldn't even say late. The process has been ongoing. We were brought into the case right before the lawsuit was filed. I've since reviewed the images. I've since reviewed the body cam videos, both in the initial redacted form prepared by the city and in the additional redacted form prepared by the city after the TRO was issued. This is not an easy case. I think Ms. Batista and the city did an excellent job in coming up with a workable balance, the most workable balance that could be struck under the circumstances. And it is unfortunate that the release of these imagery It's unfortunate that it will make it onto the internet. It will be splashed across news articles, and it will cause the victims' families distress. That, unfortunately, is what the statute seems to require, at least as I read it, and at least as I understand the facts at issue here. Maybe maybe the statute to be changed. Maybe the Idaho Supreme Court has to clarify the interpretation of it. I don't know if this dispute is going to be resolved here, simply by virtue of the fact that we are talking about a statute that seems to have perhaps unintended, perhaps intended negative effects when we're talking about murder investigations. And I mean, I think I cited this in my brief, but some other jurisdictions have laws that specifically, it would appear, address this exact scenario where investigatory records, whether they involve murder investigations or not, they are generally not subject to disclosure. They're very limited. Pennsylvania has a statute that does this. Idaho, for good or for ill, does not appear to. We are simply, and by we, I mean myself, my office, and the city of Moscow, are simply trying to deal with the competing interests that the statute has created and do what we can to balance the public interest in getting sunlight being the best disinfectant versus the very understandable concerns of any number of families of the victims. And so, Your Honor, if you have any questions, I'm happy to answer them. And I would also point out that if Your Honor needs additional time to craft a ruling, if Your Honor needs additional briefing, Ms. Batista and I have covered this previously. We would be happy to leave the temporary restraining order in place for a limited period of time, simply to allow any additional briefing that the court considers necessary, or simply to allow the court to make a informed, full, and reasoned decision. So just throwing that out there. But if you have any questions, I'm happy to at least attempt to answer them.
All right, thank you, Mr. Bliscow. I do have a couple of questions. So the city, as I understand it from the declarations that were submitted, has responded at least to 2 different requests for this information. The first of the photographs that were blurred, the city did that that was prior to this case being filed. The city took it upon itself to blur the faces. It redacted personal information for witnesses and other non-law enforcement individuals. They blurred bodies, they blurred photographs within the rooms and other items within the rooms, and then also VIN information on a number of vehicles, license plate numbers, including 4 vehicles that belong to the victims, or the deceased, I should say, in this case. The reason I believe it's incumbent that we use the term deceased as opposed to victims is because there are other victims in this matter, and I think that being identified as far as the criminal proceeding goes and how that definition applies across whether it's a constitutional protection for those victims that are named, but also under Title 19 that both counsel have pointed to. So one of the questions that I have is in responding to those requests, initially, and then also subsequently after the temporary restraining order was issued, which at that point was very limited in what this court issued. That being that the city was restrained at that time from releasing any additional audio, video, or photographs or images concerning or related to specifically Madison Mogen's bedroom, no one else's. The city then released a body cam video with utilizing black boxes over all of the bedrooms within the home, not just the decedent's and not just Miss Mogen's, as was ordered by the temporary restraining order, and also muted certain audio within that. So my question is for you, the city has to justify, obviously, as you know, under the Public Records Act, the city has to justify those kind of redactions when it's responding to a request. What was the justification for that, or what statutory basis did the city use to respond to those requesters and say, this is why we are blurring these images?
My understanding, Ms. Batista can correct me if I'm wrong, but my understanding is that we relied on your order, and the fact that Mr. James had indicated to us that he was intending to bring claims on behalf of other, and I apologize for the imprecision in my usage of deceased and victim, Your Honor. But my understanding is that the statutory basis, I don't know if there's a specific statutory basis that the city relied on other than to say, we have a court order that says we can't release bedroom imagery of this victim. We have a plaintiff's counsel who has indicated that additional parties are coming. It was abundance of caution. I think that if we had gone the other route and simply redacted Miss Mogen's bedroom with black boxes and nothing else, I'll be frank, I would not want to be back in front of Your Honor arguing and explaining why, when we knew additional plaintiffs were coming and were going to be added, and as it turns out, only one was, why we defied, if not the letter of a court order, but why we defied the spirit of a court order that clearly had found that bedroom imagery was potentially problematic. Rock in a hard place, Your Honor. That was the basis on which we released that body cam video with those particular redactions of all of the bedroom imagery or any descriptions of the bedrooms. Again, Ms. Batista can correct me if I'm wrong, but that is my understanding of what the basis was.
But I guess I'm asking, before any court intervention, the city released images to, as we know, KTVB, I believe was the requester, that have been disseminated. I don't know who or how, and that's not even part of the analysis here. It doesn't matter, but they are widely available on the internet. Though the city made a decision at that point in time, based upon their statutory duty to respond to a public records request, that they were going to blur certain things, which I went over. There was no court order in place. What I'm wondering is, what was the city's justification? What were they using to justify that blurring or redaction of the images at that point in time? Was it this provision, the unwarranted invasion of personal privacy, or was it something else?
Ms. Batista, you're on the call. Would you like to address that?
It was based on the unwarranted invasion of personal privacy.
Okay. So then my next question is, if that was the case, whose privacy interest was the city asserting? And was it that it was an unwarranted invasion of the personal privacy of the deceased person themselves? Or is it of the family members of the deceased? Do the deceased individuals maintain a privacy interest in their body, their blood, their effects, their personal identification, the VIN on their vehicles, the license plate numbers on their vehicles? Because those were blurred. So is the city maintaining then, if the family members do not have a claim or a privacy interest under this particular exception, is it the deceased person? And how far does that extend, Mr. Pliskow?
Well, I think that, we're getting into an issue that Mr. James got into as well, which is whether and to what extent there is an attendant interest beyond what the deceased has. I think that there is undoubtedly, whether in Idaho or elsewhere, a common law privacy interest. Favish, the United States Supreme Court decision, talks about that, at least in general terms, maybe not specific to Idaho. But I don't know. is the simple answer, Your Honor. It is difficult to say. The statute that defines what an unwarranted invasion of personal privacy is seems to suggest that it is a narrow interest that inures to the benefit of the deceased only. That's the only one they're talking about there. There's no mention of family members. There's no mention of other interested third parties. And yet, I mean, you can look to other provisions of Idaho code and find language that seems to suggest that victims have some sort of interest that might apply here. I think that I think the court has to go by what the specific statute says here. Specific derogates from the general. The specific provision we're talking about here is the specific statutory language that governs the release of public records. And to govern the release of public records, this statutory provision talks specifically about what is an unwarranted invasion of privacy and not. And that's the term you have to look at. Looking elsewhere to terms that are not referenced, the legislature could easily have cross-referenced these statutes and said, this is what it is defined as for these purposes, subject to the limitations set forth in statutory provision X or Y, or in addition to the provisions set forth in statutory provision X or Y. That's not what the statute says. That might be what it should say, but that's not what it says. And to the extent that we are talking about the redaction of private information of what would be like VIN numbers, other personal identifying information specific to the deceased. I wasn't involved with the additional redaction process, so I will freely admit that I might have to turn it over to Ms. Batista on this because I hate to throw her into it, but the exact basis on which these were released is she is much better versed in the analysis and the thinking process that went into that. So, Mia, if you would like to address this, if you can address this, please do. Otherwise, I will attempt to muddle my way through the city's thought process.
Your Honor, if I understand part of your question, it was, involving the redactions of the vehicles in the parking lots and the VIN numbers. There are sections within the Idaho Public Records Act that allows you to redact personal identifying type of information. When reviewing those, we felt, in part because of the way these materials were being shared nationwide, really, that not knowing exactly who those vehicles belong to, what could be done with that sort of information, we erred on the side of trying to protect whoever the owner of those vehicles would be, trying to protect their privacy interest. And that's why we redacted those. I'm trying to find the exact section, but I'm not able to find that right this second. But there is a section that allows you to redact personal type of information, identifying information that would include things such as, financial account numbers, social security numbers, driver's license numbers, certain information within a driver's license number, and things of that matter.
So I guess another question I have then, going on this same line, is that if we are to interpret the statute as Mr. Pascal, as you've indicated, and following your briefing and saying that it doesn't specifically say that the family members have an interest, a privacy interest. In subparagraph 17A, Roman numeral 2, it says that the disclosure or release of information is likely to violate legitimate and substantial privacy interests of the person identified when such interests are weighed against the general public information. If Mr. Pascal or Ms. Batista, if the court limits the interpretation of of the person identified being the decedent themselves, then, and the city were to release images, video, not blurring, not redacting, just showing the dead bodies, what's the recourse? The decedent person doesn't have, they're not here to challenge that. So who then on their behalf but the family can? I mean, what's the point in having that particular subsection unwarranted invasion of personal privacy if it's left to the decedent to try to come forth to claim some interest in saying you can't release an image of my dead body. I mean, that doesn't logically make sense. So I'm trying to understand how we can be so narrowly interpreting it if that's what the city is asking.
Well, for one, this may be splitting hairs here, but estates of deceased individuals have residual interests. The mere fact that a family member can't bring a claim on behalf of a deceased, but the estate can, is not a concept that is utterly alien to law, whether in Idaho or elsewhere. I think it might be unusual to interpret, a right of survivorship in this context that does not inure to surviving family members, but does to the estate.
So sorry,
But it's not completely unprecedented.
I'm sorry to interrupt you, but are you saying then that what should have happened is that these families should open up a probate and be representatives of the estate of these two individuals, or in order to come and assert? I'm confused on what you're distinguishing.
I mean, yes, I think that is the distinction that I'm drawing, simply to say that if it's a personal representative of the deceased or the deceased estate bringing claims, that is the answer to your question. I don't necessarily think that it's an unusual result. I will freely concede that, and it may or may not be what the legislature intended. But at the end of the day, it is what the statute says. And I mean, that is where we come down. And unusual, unorthodox, strange though it may seem, that seems to be what, in our view, the statute suggests.
Okay, and so if the court does find that these particular plaintiffs, have a privacy interest, does the city agree that the other deceased victims' families would have a similar interest? Or does the city believe that they should be required, as Mr. James has done here on behalf of two of the decedent's families, filed a suit to assert such interest?
I think that I can only answer the claims of the parties that have filed suit here, but as a general principle, I don't think there's much difference. Yeah, if one set of family members have a privacy interest, so do all. And I mean, there's a reason why the materials, the additional redactions the city has prepared, apply to all bedrooms. So go one, so go all. It's the same thing. And I don't necessarily think that there is any reason why, at this point in this litigation, a separate suit would have to be filed by the additional family members. If Your Honor says there's a privacy interest here and it weighs strongly in favor of X or Y, the city is going to abide by that ruling across the board here. It's not going to sit here and play games and say, well, two family members or two families have brought suit, but the other two haven't. So these images can go out, these images can't, and too bad you didn't file suit. I think that we do not dispute that the city has an obligation to apply these statutory exceptions and do so in good faith and to the best of the city's ability. If the court gives clearance and guidance, we might appeal your ruling, but we will abide by it. And if the clear implication of it is that these are privacy interests that apply to all of the family members, and the weighting of the competing interests does not favor disclosure, we're not going to stand on principle or procedure and say, no, two families have voiced their interests, four families haven't. Two images get released and the other two don't. There's no difference here. We will abide by your ruling, whatever it is, Your Honor, subject to potentially appealing it.
Okay. And then, so my last question, Mr. Foscal, sorry, I do just have one more. So the city has asserted, obviously, that the public has an interest in law enforcement's investigation. That is the primary interest that we're weighing against this privacy interest. And what whether or not the release would constitute an unwarranted invasion of that personal privacy, as opposed to, say, a warranted invasion of the personal privacy. The videos depict law enforcement's actions, as we know, as far as going into the scene and those things, as well as the written reports that the city has already released or made publicly available on the website. So I am wondering how that public interest is enhanced with images of the bodies, the blood spatter, the blood stains, when all those descriptions are available in reports. How should we weigh that, or the court should weigh that against the privacy interest? I guess I'm wondering, what is the threshold the city sees as the unwarranted invasion as opposed to just a warranted invasion?
I mean, Your Honor, at some level, as we set forth in our brief, it is difficult for us to answer that question. We aren't the party that wants it. It is difficult for me on a personal level to understand why imagery, body cam videos, and what have you, why they are necessary, what clear, legitimate interest their disclosure serves. I'm not the requesting party. The city has 200 of them lined up. If we turn around and say we draw the line somewhere, it might satisfy some of them, it might satisfy all of them. I don't know. The city might end up defending several lawsuits from parties that are interested and think that the precise imagery that you have just listed off is utterly essential, whether because they have questions about the investigation, whether they have questions about Mr. Koberger's guilt, whatever the reason may be. We can only speculate as to what that might be, or whether those lawsuits will be filed. At the end of the day, a line had to be drawn, and our understanding is that where warranted and unwarranted lie here, it is, I mean, it doesn't end at the edge of one of the deceased bodies, but it's kind of close to that. Crime scene photographs that show dead bodies are clearly an unwarranted invasion of personal privacy. There's a Supreme Court case that says exactly that. Justice Kennedy talked about it at length. We do not dispute that. However, body cam videos, photographs, other records that were compiled during the course of the investigation that are careful to omit imagery of the bodies themselves, that show how officers processed the scene, that showed how officers investigated the crime, and that dispel beyond, in my view, any possible basis to question that this was a properly run investigation, and there is no reason to doubt the guilt of the party who has admitted that he committed it. I think that it is nothing short of conspiracy theory that gets into why these materials in any form, redacted, any form greater, I should say, than, all right, let me back up that just a second. I do not see how anything other than conspiratorial interests would support the release of imagery and body cams beyond the version the city initially prepared and that initially provided to the court for its review. I also don't see how the city can reliably stand up in front of a judge, whether it's this judge or another court, in an action brought by a requesting party saying, we need this imagery. We think that it has these redacted photos with these black boxes, that the second set of redactions prepared by the city, or something in between. We don't think this is enough. We think these are investigative records. We think we need them to prove or disprove what we think are our understanding of how things went down. Bottom line, as I said, Your Honor, a line had to be drawn somewhere. And if the city came down slightly on the wrong side of the balance. I don't know what there is to say other than we will accept Your Honor's assessment of where the proper balance lies. We might appeal it. We will, however, comply with it. And we are talking about, at the end of the day, concepts of warranted and unwarranted. I mean, Your Honor has been on the bench for a long time. Warrants, reasonable suspicion, Fourth Amendment. These are not standards that are amenable to mechanistic, clearly defined, easily applied in all circumstances definitions. Courts have been wrapping themselves in knots since the beginning of our country, trying to define what is reasonable suspicion, what is probable cause, what is a warranted intervention, what is an unwarranted intervention. And I don't know what else I have to say other than we think the line was appropriately drawn by the city in this case in the initial set of redacted photographs and videos that it released. If Your Honor disagrees, we will move from there.